start off with something, a motion that was put into court. It's a motion to suppress evidence. And that motion to suppress evidence, basically, in the motion, the lawyer who ran as against the current Attorney General Gansler in Maryland, he says that I was seized illegally. And he's asking for the evidence to be suppressed. This is at the end of the duress, when I was basically taken to what is, if we were in China, it would be called an ankang, which is an asylum where they keep nuts and where they send political prisoners, trying to say that they're nuts or to re-educate them or to drug them out of their gourd. And in fact, this is what people tried to do to me. But you will see that Sims says here, hold that he was seized illegally. He also says that I was seized twice illegally. But I just want to, get this on there so that people can see that others are saying I was seized illegally, and this was a motion put into court to suppress the evidence about the illegal seizure. And that evidence also deals with property.
When was this?
Well, this is 2007. I can give you the exact date where it was said, but put in. But that's going to be on the signature page. But you see, it's a motion to suppress evidence, and he's talking about that. Began an effort to obtain evaluation and sale of several different products. So we're talking about seized illegally, and there's products involved. Now, those products, in fact, are inventions of mine. They're intellectual property. And you will see when we get back to the scroll that that intellectual property was deemed to have worked. Indeed, if we go into this scroll of silence, the electronic file part, you will see that different people are saying that there is intellectual property that should be adjudicated for my health and well-being. For instance, right here we have psychiatrist letters. This is again in the tail end of the duress effort, when they're just trying to get me out and not deal with all of the other matters around the getting me out of this duress situation. But in fact, we are talking about theft by extortion. Now, here are signed statements by psychiatrists, Dr. Guzman, a Dr. Spingard, and a social worker, Mary Meredith Malloy, and they're saying, well, I'll read this to you. Mr. Sebastian's capacity, this is for the legal file, mind you. Mr. Sebastian's capacity and competence to contract and capacity and competence to file complaints that should be answered by state, federal, criminal, and civil courts. And this is the lead psychiatrist at Springfield Hospital, their Department of Mental Health and Hygiene. And he's saying that it is my professional opinion, as well as that of Sebastian's current treatment team, comprising doctors of psychology Spingard and social worker Ms. Meredith Malloy, that Sebastian has had and retains the capacity and competence to contract. This is also apparent as reflected by a letter by attorney Howard Feldman, Esquire, dated November 28, 2005, see attached. In our collective opinion, in terms of mental health, Mr. Sebastian's capacity to contract has never been impaired or been subject of question, evidenced by our review of his previous history. Here they're saying, further regarding any intellectual property Mr. Sebastian may have and seemingly has. Again, this is the crux of the matter. This is why the whole thing started, because people in government and industry wanted to do what is known as theft by extortion. There's 7 criteria, mind you, for theft by extortion, but we'll get to that in a minute. Further regarding intellectual property Mr. Sebastian may have and seemingly has, his right to have claims and complaints answered appropriately, as well as his right to court adjudication, should not at any time, present or past, have been or be denied under the rubric of mental health reason. Now, the reason they're writing this is because people slandered and they trumped charges and they fabricated evidence and they refused to honor or look at my claims, which is part of any defense. You know, you've got two parties that are saying different things, and they each present their argument with their evidence. And in law, officers of the court, if you look at theft by extortion laws, officers of the court do not have the right to ridicule you or deny your right to investigate your claims. Now, if you go back to the Sims motion, he's saying I was seized illegally because nobody investigated my claims. Instead, they just acted on their claims while admitting first cause, proximate cause, probable cause evidence. Now, when you're in court, your first cause is usually your cause of action, and what happened was that I invented stuff, and some of it went to government, and they refused to let me know what they wanted to do with it. Now, government's not allowed to just take property without honoring your right to have that property. You know, if they take property, they've got to pay for it if they want to keep it. And there are laws that we can go to, and we'll see that show the same thing. But I just wanted to begin with this, because when you see that others are saying that I'm competent, and mind you, they tried to say that I was not competent, that I was delusional, that I had grandiose and persecutory delusions, and this was a 2.5-year episode when I was taken to a nut house, Springfield Hospital to be specific. And in the end, when the shrinks couldn't prove their case, after hearing after hearing after hearing, after people were denying my right to witnesses, my right to subpoena, my right to present evidence, and I documented everything, they failed to make their case, which was to say that I was not competent to stand trial over Trump charges by the federal government and by the state of Maryland. And here you will see another...
How long did they keep you?
2.5 years, basically. And you will see here that on 12/15/06, they decided that upon psychiatric reevaluation, it shows that he is free of any delusional thinking and that he requires no psychiatric medication. Now, mind you, this psychiatric medication that they wanted to give me gives you delusions, can drop you dead on the spot while it destroys body organs in so many horrible ways, as well as giving you permanent twitches and drooling and your body overheating so you can't exercise. It's real horror stuff that's for very sick people.
What's the name of the medication?
That was haloperidol, is what they tried to get the courts to force drug me with against my will. Now, mind you, you have to remember the background of the law dealing with crazies. You can be a crazy on the street as long as you're not a danger to yourself, others, or property. But if you become a danger to others, yourself, others, or property, then they can hold you and they can force medicate you if they can prove this. What happened initially was I came up with several different inventions, one of which had security implications, which went to DARPA. DARPA is the Military Technological Proving Ground. DARPA doesn't even take any inventions to review until you've got 2 proofs of principle from other competent people who are in such whatever field it is that you are dealing with. And you will see here, for instance, that I have emails that went to DARPA and emails that DARPA sent back to me. In other words, I've got, the document date and time stamp stuff that you need to prove that 1, you came up with something, 2, you sent it to somebody, 3, they received it, and then there are the laws that deal with, if government receives something, they have to pay for it. If they want to keep it and use it, then they have to pay fair market value for such.
Right.
Well,